Good afternoon. Thank you for joining us for part 2 of our webinar series, Legal Planning for Specialty Crop Producers. My name is Jackie Schweichler, and I have a few housekeeping notes that I'd like to go over first. First thing, please note that this webinar is being recorded. All registrants are going to receive access to this recording and the recordings of the other presentations in this series. Check the bottom of the reminder email that you received from Zoom to find the link to the first recording. So you should have an email that you received about an hour ago and maybe one yesterday. And at the very bottom of that email, there should be a link. If you have any questions during this presentation, please put your questions in the Q&A. We'll save some time at the end to go through any questions that we receive. If you would like to get a copy of the PowerPoint, check out the event page on our website. It's not posted right now, but it will be either by the end of the presentation or very shortly thereafter. Before we get started, I'd like to provide a little background on the Penn State's Center for Agricultural and Shale Law. Our director is Ross Pfeiffer. We also have Chloe Marie, who is our research specialist. And in a couple minutes, you'll meet Brook Duer. As you can see on this slide, we provide quite a few different written work products on our website. If you need to learn more about a specific topic in agricultural law, you can check out the Agricultural Law virtual resource rooms. If you're more interested in seeing a timeline of how important topics have developed, you should see our Agricultural Law issue tracker. If you'd like to check out or have routine updates sent to you, you can subscribe to the Agricultural Law Weekly Review. With that, you'll receive a once-a-week email with all the most important updates in agricultural law. For those of you who don't have time to read another newsletter, you can subscribe to the Agricultural Law podcast. Our podcasts can be found on all the usual podcast streaming platforms like Spotify, Apple Podcasts, Google Podcasts, and you can also find that on our website. To get to our website, go to aglaw.psu.edu. That's aglaw.psu.edu, and I'll put that in the chat at some point today too. So in addition to all of our other agricultural law resources, we also operate the Pennsylvania's Agricultural Mediation Program. This program provides mediation services to agricultural producers for a long list of issues. If you have a situation with USDA and you're having trouble getting through to them, you can send me an email. If you have a neighbor who's threatened to sue, send me an email. Most of us would prefer to avoid going to court whenever possible. Plus the program right now, it's currently free. So it's a great opportunity to resolve conflict and save your wallet at the same time. Here's my contact information. All this is available on our website. And over the next few slides, I've just listed the 6 topics in the legal planning series. The first presentation listed here, it's past, but as I mentioned, you have access to that recording now. And go ahead and mark your calendars for the next presentation. It is Business Structures for Operational Resilience and Liability Avoidance. This topic will review the various forms of business entity structures that may be employed by specialty crop producers. We'll cover the attributes and pros and cons of each, the formalities that must be followed to maintain financial and legal liability protections. So keep that on your calendars, April 6th. And the next one after that is going to be November 16th. And the 5th topic, that's going to be November 30th. 6th topic will be December 14th. Again, you can find out all this information on these upcoming webinars in this series on our website. Last but not least, we'd like to say a quick thank you and note that this presentation was created as part of the Pennsylvania Specialty Crop Block Grant Program. Near the end of the program, a few minutes before the end there, I'm going to post a link in the chat to our specialty crop producer survey. Please complete this survey. It's very short, it should only take a couple minutes to fill out. These surveys help us a lot, so we really appreciate it if you're able to complete that. Now, without further ado, I will turn things over to Brook.
Hey, thanks, Jackie. I hope everybody can hear me. Let me get myself set up to share here in a second. Again, I'm Brook Duer. Most of you, or many, might know me. Had a career at the Department of Agriculture, and now I work here at the Ag Law Center. And first couple slides are just a same as Jackie's slides, telling you a little bit about this series. And again, I have it sort of divided into 2 sections. The first 3 are sort of the spring 2022 sessions. And we're right in the middle of these 3. We're on topic 2. And then This is the fall 2022 session, so we're going to take a break after the November session, and then we will pick up again in November. In the meantime, we are going to have a little get together at Ag Progress Days, which is going to be a recap of the first three and having some live sort of workshop information and sort of conduct a workshop with our attendees to talk about what's most helpful for them and get a little bit of feedback on how the presentations have gone so far. Okay, again, this is now topic 2. Legal liabilities in selling raw and processed specialty crop products. And our objective here is to educate producers on the various theories of common law legal liability, and including the concept of products liability that arises from the production and sale of both raw agricultural products and value-added processed products, and also talk about the role that insurance has in protecting against claims. Now, what is a legal liability? And that some of these introductory slides are important because they lay the groundwork for what's going to follow afterwards, so that we're all can sort of be on the same page and be using the same terminology for things. So, what's a legal liability? Well, it's a right to make a legal claim against a person or a business that is capable of being enforced through filing a lawsuit in a court of law. So, that's sort of the theoretical concept of what we're talking about. And we're talking about how to try to avoid these things, or to try to avoid them hurting you financially or otherwise. Now, most legal claims never even get close to being filed in court. But the reason that they're of concern is that they could end up being there if they aren't dealt with. And most of the time, legal liabilities get dealt with through an insurance company making an indemnity payment. That's the term for it. Other people call it as, oh, they're settling a claim, or there was a settlement or something like that. Technically, the legal word for that is that's an indemnity payment. And now that's for tort claims. There can also be legal liabilities that arise from contracts. Now, what we're going to talk about here today is tort claims. However, just be aware that, of course, contracts can also be part of the equation. Contractual liability is sort of a separate thing that we'll talk about in other sessions. Now, civil liability versus other forms of liability is something to just grasp very quickly. Civil liability is a claim or a lawsuit that's brought by a private party, usually based upon a contract or some tort liability, which we will talk about what the word tort means. The remedies in civil liability situations are mostly the payment of money to an injured party. Sometimes there'll be some type of an injunction, which might be an order to stop a certain conduct or something of that nature that a court is entering if the claim ever goes to court. Now, this is sort of contrasted with criminal liability, which is, everybody knows what it's like to get a speeding ticket. That's a form of criminal liability. It's brought by the state. In that case, a speeding ticket is handed to you by a police officer and filed at the district justice. And it's because that the legislature has declared that there is some public wrong that should carry a penalty of some kind. And the remedy is a fine, or, in an extreme case, jail for some other types of criminal liabilities. But that's just, we're talking about that to set that aside. And there's also the thing called regulatory liability. Regulatory liability is failure to follow regulations from government regarding the operation of your business or the conduct of your maintenance, let's say, and other things that you conduct activities on your real estate, on property. So, and usually the remedies for a regulatory liability are things like a fine from a state agency, or to correct the conduct, to stop doing whatever it is. If you're leaking some chemical into a waterway, for example, you get an order from DEP that says to stop doing this, and they give you a deadline and that sort of thing. And sometimes there'll even be something that's called like a cease and desist type order. And again, so those are the contrasted attributes, so to speak, or the features, or what civil liability is versus what these other things are. Now, later in this series, we're going to have an entire series on regulatory liabilities. That's one of our later ones in the fall. But this time we're going to be talking about civil liabilities. And specifically, this is about civil liabilities from the sale of specialty crops, either raw or in a processed form. Now, we talked about torts, which is a type of legal claim that can give rise to civil liability. And that's kind of what we're going to talk about here today. Again, we're not talking about contractual liability. That's also a separate thing. Now, what's a tort? Okay, it is an act or omission that results in injury or harm to a person, property, meaning real estate, or some other type of personal property, a motorcycle or a bicycle or a tractor. Or it could be a harm to reputation. Now, this is contrasted with a claim based on a contract, as we talked about before. Today, we're going to just talk about injuries to the person. And that's where the word personal injury comes from, is because it is a type of legal liability that results from injury to a person. And so we're not going to talk about injuries to property, but you can have injuries to property. You know, somebody chemicals leak onto your neighbor's property, then that's injury to their property. Or reputation, there can be business reputation torts that, you know, you maligned my business, et cetera. Those things are pretty, or you get defamation actions. That's what the reputation claim would be. But again, we're just talking about injuries to the person here. Now, the example of the main type of tort claim, the main type of legal liability that we're going to talk about here today is a negligence claim. Now, with the first session in this series talked about negligence claims in relation to the operation and maintenance of real estate, or I should probably say the ownership, possession, control, maintenance of real estate. And that's Jackie did that one a couple of weeks back. So now we're going to talk about a different type of negligence claim. My example here is, okay, so Farmer A operates a pick your own strawberry agritainment type of operation. A chronically leaking manure pit discharges into the strawberry fields where the public is coming to pick and contaminates the soil and the strawberries, and several customers become ill. There you go. There's an example of a legal liability in the nature of a personal injury that is also probably going to be couched as a negligence claim. However, in this slide, I want to sort of talk about, well, these facts could lead to some of those other types of liabilities we talked about too. There could be regulatory liability from this scenario. Of course, your leaking manure pit is going to most likely end up being some type of a DEP regulation violation. So you could very well have regulatory liability from this example. And could you have criminal action? In other words, a criminal liability from an example like this? You actually could, and it's very, very rare. You know, the ag world kind of took a big shock a few years ago when this Peanut Corporation of America case occurred, which was a situation where a peanut processor down in Georgia who had a chronically contaminated peanut processing plant that they knew was contaminated. I think it was salmonella, or it might have been E. coli. I forget which pathogen it was, but it was so out of control and had run so rampant in their manufacturing facility, and they had done so little to control it and had not controlled it, that the entire product line and the manufacturing line was contaminated, and they just kept manufacturing their products and putting them out on the market. And there were multiple illnesses, and the executives in that company actually got charged criminally because of how long they had let this go on with full knowledge of it. So that's a very, very rare case. Again, I'm not including this to scare you. I just putting it in here because it happened a few years back, and some people might remember that, but it was quite the earth-shattering development and really an unprecedented kind of thing. Okay, now one of the attributes and one of the things that a civil liability and a civil claim has is that there's a certain level of proof that has to be met if the case were to go to a jury, and that's of course the context in which you have to evaluate all of these claims, is what if they did go to a jury and let's say your insurance company couldn't settle it? Well, that's how you evaluate them. You have to sort of predict what a jury might think of something. So one of the things that happens when you go to a trial in a case of this nature is proof of facts has to be by a preponderance of the evidence, which is just tipping the scales ever so slightly in favor of whoever is advocating that X, Y, and Z fact occurred. Now, this is in contrast to what we all know of as the criminal standard when the district attorney or a U.S. attorney brings a criminal case and there's this beyond a reasonable doubt standard. That's not what civil cases operate on. This is a much lesser standard. So it is just, well, which one do you believe? Which one has that much more truth and credibility to it that you believe it? These are usually brought, the types of claims that we're here to talk about are usually brought in your local county court system, which is our state court system, just happens to be organized by counties first, and then it goes to the next level of appeal, which is larger than counties. And then ultimately we have a Pennsylvania Supreme Court. But the bottom line is, you probably understand that there are federal courts too. Well, what do federal courts do? Federal courts exist for several reasons, all arising out of the drafting of the Constitution way back when. And one of the reasons for federal courts to exist, they can hear these kinds of cases and these kinds of claims when they are disputes between citizens of different states. So theoretically, if somebody comes to your farm to purchase product, let's say, and they're in somehow they contract a foodborne illness from that product, and they're from Delaware, and this occurred, they purchased it in Pennsylvania, theoretically, that instead of going to the local county court system where you are, for example, they could actually go to federal court because it's between citizens of different states. That's one of the reasons the federal courts existed. There was this idea that individual state court systems might be biased towards their own residents. So the federal courts were made available for that. Also, federal courts exist for if there are questions of federal law, enforcing a federal law, or there are some other reason that the case exists because of federal law and it's interpreting federal law, applying to federal law, etc. So I'm just giving you that explanation so you understand these types of personal injury cases are generally done in state court and they start at your county level here in Pennsylvania. Now, possible relief in a civil case, basically you have medical expenses, lost income, we call those economic damages. Then there's this more amorphous idea of pain and suffering, the non-economic damages. And again, that's all just a question of, well, what would a jury think of this? And, you know, you can have some pretty, since we're talking about foodborne illness very prevalently here today, you know, you obviously have probably been exposed to news accounts and other things with regard to foodborne illness cases. And you can have some pretty significant illnesses and medical problems caused by foodborne illnesses, or you may not. You could have a very transitory passing illness that essentially there's a 100% recovery within a very short period of time. So it can run, these kinds of claims can run all over the gamut of how severe they are. And again, that's measuring them by what would a jury give somebody because they suffered through a couple of days of illness versus they had to be hospitalized with kidney failure or something like that. So that's essentially how you look at these cases. This pain and suffering sort of component of the compensatory damages ends up being a big driver of what is a claim actually worth. There can be other types of damages in a civil case, like punitive damages or injunctive relief. Again, when I talked about that Peanut Corporation of America, the individual persons who were made sick, I'm sure that they had punitive damages claims in the claims that they made and the lawsuits that were filed, or at least the claims that were asserted against the insurance company for Peanut Corporation of America. And punitive damages were part of that because it was so outrageous. I don't think there's going to be very many of those within the scope of what we're here to talk about today, but just understand that that's what that word means. Now, again, there are several different types of torts. We've been talking about negligence initially here, and we're going to talk about that some more. And then we're going to talk about products liability, which is the fourth bullet on this particular slide. We also have other kinds of torts that exist, like an intentional tort, which is things like assault and battery, or false imprisonment, things of that nature. We're not going to talk about those here today, but that's what an intentional tort is. And we'll talk about intent later, which might help you put that in context. And there's a thing called strict liability for ultra hazardous activities, which is like, let's say you're blasting in connection with some construction, things that are involving activities that are extremely dangerous in and of themselves. And that's a whole issue that it's a type of tort. We're not going to discuss that here today. So we're going to talk about negligence, and then we're going to talk about products liability. And they're really two different things, but I think what I want you to get out of this is an understanding that more or less sort of sews them together, because as a purveyor of food and products that are intended to be consumed or for human consumption, for the most part, that's what I assume you are if you're a specialty crop producer. Those are the areas that you're going to be dealing with. If you're a seller and a producer of, in the green industry, let's say, and you're selling plants, et cetera, then that's you can still have these negligence products liability. It's just a question of those generally aren't causing personal injury. They could. They might be doing something else, like you sold a diseased plant to somebody who then planted it and ended up spreading a plant disease to the rest of their property. That's an example of a tort that is an injury to property. And then you would value it based on, the replacement of everything that was lost or killed by the disease, that sort of thing. So just giving you some background, some of the bigger picture. Okay, so negligence. What state of mind, what's required to show that somebody was negligent? Well, the first and most important statement that is always thrown around is the failure to act as a reasonable person would act under similar circumstances. And in what way? Well, you're supposed to act in a way as to prevent injury to others. So it's negligence is another word for what a lot of us commonly would call carelessness, thoughtlessness, oversight, that sort of thing. So this concept of reasonable person is really important, because it's the failure to act as a reasonable person would. Well, how is a reasonable person? How would they act? Well, that's the case. That's the question in a lot of these cases, is what should you have done differently than what you did to try to protect against injury to someone? And we'll talk about that in a minute. Now, just to contrast this again, negligence versus other types of state of mind in other types of liabilities. In criminal liability, you generally always need an intent to have done the actual act that occurred. So unlike negligence, where you maybe, you didn't intend to make somebody sick, but you might have done some things somewhat sloppily or carelessly to lead to that result, criminal liability requires that you have an intent or something equivalent. Now, these Peanut Corporation of America case that I mentioned before, that was done those people were prosecuted based upon what would be called recklessness and essentially a disregard for the fact that they knew they were making people sick, or potentially people would be sick by eating products from their plant because their manufacturing plant was contaminated chronically with salmonella. Now, regulatory liability, in other words, having a liability from violating some requirement of a state agency or the government, is generally does not require some type of intent. It's generally, if you did the thing and it was against the regulations, then you're guilty of it. There can be differences and exceptions to that, where there is sort of a state of mind required to be shown that you knew you were doing something that was against the rules, so to speak. But that's generally not a requirement in the regulatory liability context. Okay, now, negligence has 4 elements. Again, this is not the most critical part of retaining the information here, but I'll just give it to you so we walk you through these things. You have to prove that there's a duty to protect others from injury. And when you're selling food, yes, you're obviously selling something for human consumption, so you have a duty not to make them sick. you show that there was a breach of the standard of care. In other words, this reasonable person standard that was owed to the injured party. And again, this is in a negligence context, so there'd have to be some proof that you did something in a way that that reasonable person wouldn't have done it in your circumstances, conducting the business that they are conducting. Then you also have to have causation or proximate cause and damages. But again, we're not going to harp on those. I'm just walking you through these, and just stick with me, and then we will get to where we're going here. Now, when is there a duty? This is important. As I said, there's a duty when you're selling a product for human consumption. There's a duty to make sure that you're not making them sick by the consumption of that product. That arises from what's called common law. In other words, there may not necessarily be a law on the books that says that, and if you've many times there are, but the common law, which is essentially handed down to us all the way back from when we started this country, and it was brought over from England, basically, is where the principles of negligence originated, and that's what's called the common law. And for example, let's say that a farmer is moving farm equipment on a public roadway. Well, there are rules and regulations about that, but just in general, you got to put that, move that equipment in such a way so that you're not injuring people on that roadway who are using the roadway. Just like you need to operate, maintain, store that farm equipment on your own property in such a way so that it doesn't injure somebody. That is a duty that you have when you own a piece of equipment. Okay. And then this is my example here, which I've already used many times. Selling a product to a consumer that's intended for human consumption, you have a duty not to make them sick. Now, prior to industrialization and the industrial age and the turn of the beginning of the 20th century, let's just call it, perhaps there was a concept where selling a product was buyer beware. And there wasn't a duty that went along with selling that product to ensure that people weren't going to be injured by it. But that has long since gone away under our system of common law and our basic societal expectations that we do not operate any longer on commerce being conducted on the basis that it's a buyer beware situation. You buy, a food product, and can you imagine the world if you bought a food product and it was completely, as is, buyer beware, whatever results from you consuming this product is on you. It's not the world we live in, and that's not the legal principles that we live under. And that is not how our court system works. Now you can also have a duty that arises from a contract sometimes, such as my example, a farmer is contracted to do custom harvesting. Let's say that farmer doesn't do it well and ends up, damaging the farm itself, knocks down some fences, whatever, or perhaps takes out the neighbor's fence, or ends up, bringing in the hay from, the neighbor's, acreage as opposed to your own. In all of those circumstances, they had a duty not to do their work in such a way as to cause these types of damages and these types of claims to arise. So that's an example of a duty that's arising from a contract to do work. There's also a thing about assuming a duty. It's not going to be relevant to our discussion here today, but you sometimes have a circumstance where you're fine, you didn't have any duty to act, but you took it upon yourself to get involved. Well, then you end up having a duty because you have put yourself into that position. Okay, now, examples of, negligence duties. Again, I've said it a number of times. Land ownership, you have a duty of care that you, to people on the property to prevent them from being injured by any condition on the property. And that's what Jackie covered in the first session of this entire series. Now, what we're going to talk about today is the second bullet point, which is food production and sales. There's a duty of care owed to consumers not to cause a foodborne illness by the intended method of consumption of the food. That's an important little phrase right there. By the intended method of consumption of the food. Generally, what you people, as especially crop producers, would be dealing with is raw agricultural products. So you're selling them in its raw or as is state, but you still have a duty to make sure that it's not contaminated with salmonella, et cetera. Now, there's an interesting sort of gray area or interesting twist on this, because the food area happens to be one area where we do actually sell products that are raw, but yet that is not the state in which they are intended to be consumed. They are intended to be consumed after cooking. And so that makes food sales a little bit different than some products, because when you're talking about the sale of products, you go into a store and you buy a product, it's in the condition that it's intended to be used right there in the box. And dry goods, for example, would be that way. But many of our foods, or I'll put it this way, what was classified in the food code as potentially hazardous foods, are sold in a condition where they may, in fact, not be intended to be consumed in the manner in which they're sold. And that can put some interesting twists in here, which we'll just note as we go forward. So, again, we talked about what the standard of care is, particularly in a in a food sale type of context. The big question is, did the farmer or the business owner meet the safety standards expected in the business in which he or she is engaged? And we obviously are hyper aware of all of this because of the advent of FSMA. And so we'll talk a little bit more about how FSMA comes into play, but you can see from that phrase that I used right there, did the farmer or business owner meet the safety standards expected in the business in which he or she is engaged? Well, what are the safety standards expected in the business in which you're engaged? FSMA. That's the safety. That is the most fundamental, rudimentary safety standard that we have, and is new to all of us in relative terms. So that FSMA, the basic requirements of FSMA, establish the standard of care, or they establish a standard of care that is owed to your customers. So if you haven't done your FSMA compliance and you are in violation of something that is prescribed under FSMA and under the various rules, depending on what the circumstance may be, then you have certainly breached the standard of care. That's what FSMA has brought us in many ways, is a very palpable, easy to understand standard of care with regard to the production of food, which we in fact didn't have quite in that same form until just recently. Now, there can also be standards of care established by a government standard. And that's, in fact, my slides got a little ahead of me. That's exactly what FSMA does. It is the government essentially establishing a set of rules to be followed so as to prevent injury to persons by consuming or coming in contact with products from your farm. So that is establishing by government standard the standard of care for a negligence case. In negligence terms, that used to be called negligence per se, which means that, well, if you didn't do what the government's requiring you to do, then you clearly were negligent, because those are the basic, most fundamental minimum things that you need to do. It's just like driving a motor vehicle. If you didn't comply with the speed limit, and that in fact caused the injury, or you ran the stop sign and that in fact caused the injury, or you crossed the yellow line and that caused the injury, well, then you're negligent because you violated the rules of the road that are embodied in law. So you just essentially take that concept and apply it. You can then see that so much of what you do has governmental regulations involved, and those governmental regulations always establish the baseline standard that you owe to third parties not to injure them by your conduct, whether it's selling food, whether it's your manure pit that's leaking, whether it's some other aspect of your operation. So that is a really fundamental concept to take with you here today, which is if you're not following the governmental regulations that apply to the business in which you are engaged, and that failure to follow ends up causing some injury in some way, or that the injury results from the failure to follow, then that's a very, very, very solid negligence case. And that's what we call negligence per se, or that's what attorneys call negligence per se, or what just a legal term to basically mean, hey, you did it. Okay, now, causation is an interesting one. You also have to prove that whatever it is that you did wrong in terms of not protecting against injury to third persons actually caused the injury. And I'll keep moving so as to save time. We could talk forever about how you establish causation. Sometimes you have issues there. In the foodborne illness arena, mostly the issue is simply, did the person contract the illness from my product versus some other product? So maybe I had salmonella on my, leafy greens, but this person, did they contract them from those leafy greens, or did they contract salmonella from somewhere else? That's usually the causation question that's going on in a negligence case that involves foodborne illness. Now, negligence also requires actual damages. So again, if you have a foodborne illness case that causes very little in the way of injury, in terms of a medical problem, those claims don't have a whole lot of value because you have to have actual damages. You don't get a payment from an insurance company simply because, you ate some chicken that, may have been not properly, handled prior to cooking, and maybe you ate the same chicken that somebody else ate, they got sick, you didn't. You don't have a claim just because you ate it. You have to have damages. I'm trying to say that in a diplomatic way. Okay, now, there are defenses to negligence claims. Comparative negligence, which is a party essentially was negligent in their own right and helped to cause their own injury. You can have that in foodborne illness cases sometimes, particularly if you're talking about spoiled food, what exactly happened that led to this. When I used to deal with raw milk cases and foodborne illness, you'd have that many times, just in the context of how long was this sitting around, because it's not pasteurized to begin with. So in any event, we won't go there. Now, hang on, let me go. Okay. You have also in foodborne illness cases, you can have some version of what the law calls assumption of the risk, which is the consumption of particularly certain foods that perhaps carry their own inherent risk. That's, and that's again, the idea, it sort of gets around to that idea we talked about, which is you're selling a raw agricultural commodity. If it's in the form of meat, it's not intended to be consumed in that, condition. It's intended to be cooked first. If you're consuming it prior to the cooking step, well, then you may very well have assumed the risk. That's sort of part of the legal terminology that surrounds these cases. One of the other things that comes into play that's sort of an offshoot of this is this idea of, we live in Pennsylvania, so we've all probably had some exposure to these concepts of these buyers clubs, which is somebody who wants to say, oh, well, all my people sign an agreement that we're a private club and that they are waiving all claims against me, based upon any food-borne illness that they might contract from the products that they're buying from me, et cetera, et cetera. Well, good luck with that. But I will say that be aware that any signed waiver of that sort that purports to limit the rights of a child who is made ill by a food product is not going to be upheld in Pennsylvania. That's the easiest way to say it. And, so you're not protected, no matter what type of documents you use, you are never, ever in Pennsylvania protecting yourself against claims when a child is made ill by a foodborne illness. Now, vicarious liability is an important principle to understand, and I'll just walk through one aspect of it, which is, I'm going to deviate from this slide for 1 second. Let's assume that you are a wholesale seller of commodities to a retailer. Let's say it's a natural food store. You're selling various vegetables to them throughout the year as you harvest them. And so, in other words, this is not a direct sale situation, but this is a wholesale, and then someone else is the retailer. Well, you are essentially an independent contractor who supplies them with vegetables. So the principles of vicarious liability do come into play here in a negligence case, and they indicate, or they would result in the fact that you are not the retailer's employee. You are an independent contractor who simply supplies them something, and so therefore, the retailer is not responsible for what you might have done negligently in the handling of that food before it arrived at their store. But we are going to talk about products liability, which alters that, but I'm sort of setting that up so you understand what that means, and then we'll talk about products liability. Now, again, we're still talking we're still talking about negligence claims and civil liabilities from negligence. So what do? How do you protect yourself? First, you operate your business in accordance with all laws, regulations, and safety standards that apply to your industry. So whether it's FSMA, whether it's something else that applies to another condition on your farm or some other activity you do on the farm, the minimum is to do all of the things that the law requires. And you are going to be in very tough sledding to fight a negligence claim if you didn't do all of those basic minimum things that the law requires you to do. So you also need to go above and beyond that minimum standard of care for the things that are obvious to you as a business owner. So don't think that just because you have all your permits and you do all the things that you're required to do by any state that has jurisdiction over some part of your business, that you're all in the clear. You need to continue to operate your business even over and above that to prevent against injuries to third parties. Signage for land and liabilities that arise from your farm itself, and Jackie talked about this in the first section, the first session of this series. Signage is so important and so welcomed by your insurance company. Labels for food products. There is, just like signs, there is great benefit to be had from labels on your food, and some people will chuckle about things that are, food labels that you find funny, that talk about, various things like, make sure you cook this first, or, et cetera. There's a lot of things that have, found their way onto food labels, but that stuff is very, very helpful should you end up having a problem down the line. So if you're selling a raw commodity like meat that is intended to be cooked, then put that right on the label. It doesn't do you any harm, and boy, it does provide you protections should something occur. If you are dealing in raw milk, actually the Pennsylvania Department of Agriculture requires you to put a little warning on there. Put your own on there. Put something in addition to that. It's all helpful. The other ways to protect yourself against liabilities: business entity formation. We're going to have an entire session about that. That's the next one coming up in April. There are state immunity legislation for certain things that's not applicable here. But what's the biggest one? Liability insurance. That's really besides conducting a safe and appropriate business, liability insurance is really what you need to be probably your second highest priority. Now, let's talk about protections from liability insurance. Insurance may be required by various permits or licenses or state or municipal approvals that you have to operate your business. But the question always remains, well, what kind of insurance do I actually need and what does it really cover? And that is a huge question. And that is a question that people are not very good at answering. And sometimes even insurance agents aren't the best at answering that. But the bottom line is what you need to know in your particular business as a specialty crop producer who's presumably doing direct sales, but even if you're selling wholesale, not all companies are going to cover the activity of selling a product from your farm that is going to be taken from the farm and consumed. In other words, a product that is intended for human consumption somewhere else. That is generally excluded from most standard farm policies of insurance. The liability portion of a standard farm policy is, I'll put it this way, your chances are much, much better than 50% that your policy doesn't cover those products when they're consumed by your consumers. And most people don't understand that. Now, okay, we'll skip this one because we are going to have a whole session on that. We're going to skip that one because we have a little bit of time constraints. Let's talk about how you deal with purchasing and liability insurance, and we will get to the specifics in a second. Let's talk about dealing with your agent in a lot of ways, or in a number of ways that are going to help you. First of all, you need to enable your insurance to provide the benefits that you're seeking from it. So what do? All these things here. First, your insurance agent needs to be an integral part of your team, so to speak. They need to be told and understand exactly what it is that you're doing. And you need to ask questions about what is covered under your policy and what kind of coverages you should be buying. Don't just let this, go to chance. This is vital to the survival of your business. Disclose all aspects of your business to your agent and make sure you have a record of what you told them you're doing. So put it in writing through emails, etc. Create a record that you told your insurance agent exactly what it was that you were doing. I can't tell you how many times I've had people come in and they say, my insurance company, canceled me, or they found out I was doing tours on the farm or this or that. And there's this disconnect between what their insurance agent knows and what they think the insurance agent might know. And so you got to have the proof that you told them all these things. If you expand your business endeavors, tell your insurance agent. If a claim occurs, notify your insurance agency right away, or your insurance company directly, or both. And then throughout the process from that day forward, document everything that has occurred and that occurs throughout this process. Take photographs of as much as you can, preserve evidence in a safe place, undisturbed by aging or tampering. If that requires taking food samples and freezing them, do the best you can with that. It's not a perfect thing. Sometimes, depending on the food substance, but you need to make an attempt anyway. Now, let's talk about products liability. Now we're getting into the real nitty-gritty detail here, which is foodborne illness cases can generally take the form of products liability tort cases, and negligence becomes sort of a tack on. Now, what's products liability? That's a modern doctrine with regard to the liability arising from the sale of products in our modern system of commerce that essentially says it puts the burden on the distribution chain and away from the consumer who was theoretically made ill by the product, and just says, look, all parties in the chain of manufacturing, process, and distribution of this product can be made liable based upon or for damages caused by this product. And then it's up to these parties in the chain of distribution and processing and just to essentially sort it out amongst themselves. And this is more or less a 20th century invention, but the bottom line is that means that when somebody goes to a store and buys a product and they're made ill, they can sue the store, and then the store's got to drag in all the people that they that they purchased the product from, or they can sue the distributor in the chain, they can sue the manufacturer, any number of them, or all of them. And whoever the consumer may miss, the other parties in the case, basically to protect themselves, need to bring in all of those parties. So what that means is if you're selling wholesale to a retailer, that retailer is going to be looking to you first and foremost, should there ever be a report back about a foodborne illness to them. And you, as the originator of that product, assuming that it wasn't altered in any way from the time that it left your possession to the time that the consumer took possession of it, and that's a big if, then it's going to be traced back to you. So you have to be ready for that if you're selling wholesale in any way. If you're selling retail direct to consumers, well, then of course your consumer is going to know where they bought the product. Okay, now products liability doesn't require negligence. It doesn't require any proof that somebody was careless or did something that they shouldn't have done. Essentially, a product is considered a defective product under products liability law if it made somebody ill, period, end of discussion. It's now a defective product. So that is the big takeaway to understand here when you're talking about products liability for foodborne illnesses, which is the consumer doesn't have to prove anything about how the food became contaminated. If they were made ill and the food caused it, which a doctor is going to back them up on that in some way, shape, or form, then that's essentially the case. That's the products liability case. Now, I'm going to go forward to talk about insurance for products liability, and then we will go to questions and answers. Most liability insurance provisions of a standard farm policy of insurance, they exclude products liability claims. And that's what I had told you before about this idea of if someone is doing direct purchase, if you're doing direct sales and they're purchasing direct from you, they leave with your products, they consume them somewhere else and they're made ill by them. A standard policy is going to exclude that. You have to make sure that you have gone the extra step to purchase that coverage. The reason why that standard farm policies don't cover that is because they were not developed. All this policy language was developed in an era when direct sales and value added and producer processing, none of those things were the standards back then. Back then, the standards when these policies were developed, and they still exist today in the same state, was a situation where the farmer was producing raw commodities that were then going to be wholesaled to somebody else who was then going to process them, in a number of different ways, and essentially they would someday make their way into a food product. The days of direct sales were not on us when all these insurance policies were developed. And they've never really been changed in their core language. So what you need to buy is what is called completed products or completed operations or completed products and operations coverage. That's what you need to buy. So that's the key buzzword to take with you. Completed products and completed operations, that's the kind of coverage that you need. And that is what is made today to cover people or to insure people against these products liability claims. Okay, so that is the world that you're now doing business in. So to get this insurance coverage, you need to ask your agent, what's in my standard policy? Do I have coverage for completed products? In other words, do I have coverage for that product leaving my farm in the state where somebody is going to consume it? And that is, you can't, if there's only one thing you get out of this session, that's it right there. And I can't tell you how many people are not aware of that. Now, there's a couple more things to understand, particularly if you're a wholesaler and you're selling to someone who's going to retail your product. Jackie, I will finish up in a couple seconds here, and then we will go ahead. you're a retailer to whom you are selling wholesale is going to want to be an additional insured on your product's liability policy of insurance, because that's how they get covered when the consumer has a foodborne illness and there's a problem, and the store is the one who hears from them, and the store is going to say, okay, Ed's vegetable farm, I bought the peppers from you, and you're supposed to have me covered on your insurance policy as an additional insured, so that your insurance company takes care of all this. And then theoretically, and that's what additional insured coverage does, is that it covers the retailers of your product as if they are another insured under your policy. And so that's what additional insured means. It treats the person down the distribution chain as if they are just as insured under your policy as you are. Now, you are what's called the named insured in that context. And then the retailers who sell your products are the additional insureds. Same thing, flip it for a second and imagine that you're selling somebody else's products, like you may do. Maybe you bring in some outside product to sell at your farm market. That you should be looking to those people to get additional insured certificates from them that proves to you that they have enough, they have the right kind of insurance to cover claims relating to foodborne illness. Okay, this is an additional insured coverage sheet on the right. This is on the left is what's called an additional insured certificate. You may be aware of that and seen these before, but that's just an example. You can have access to all these PowerPoint slides, will be at your disposal since you registered here. So you'll have all those. Now, a couple other things. I'll tell you what, let's go to the questions, Jackie. And then if we have time, I will come back.
All right, sounds good. Just a quick note, I did put the link to the survey in the chat. So please, when you get a chance, everyone, click on that link, go to the survey. The survey is different than the poll question we just did. We just did a poll question asking how you heard about this webinar. The survey is different. It's intended for anyone here who is a specialty crop producer. If you are able to, you can hold up your phone with the camera on and scan the QR code here, and it'll take you right to the survey on your phone, if that's easier for you. I think that's it.
Okay.
All right, well, thank you everyone for attending, and we'll look forward to seeing you at our next webinar. Thanks, Brooke.
Okay, you're welcome. Thanks, everybody.